The case of Radmacher and Grantine in 2010 was a seminal case in the UK, which concerned the principles to be applied when the court is looking at the financial arrangements following a divorce and looking at specifically what weight should be given to marital agreements made before a marriage. As Mr. Lord Justice King stated in Vesta in 2018, Radmacher, these words were, represents a sea change in the UK court's approach to prenuptial agreements, whereby not only a premarital agreement is no longer contrary to public policy, but where a party has a full appreciation of its implications, the court should now give effect to such an agreement unless it will be unfair to do so. And it says, unusually, the court may, in looking for a fair outcome, give an award that exceeds one party's needs. I remember that was slightly troubling for some practitioners when reading it because, it kind of questioned, I guess, why having nuptial agreements. But I would say the key word is unusually. Yes, the court does have the power to do that. But from the cases we've seen so far, since Radmacher and to date, I would say that there's generally departure where it's due to needs. And we'll come on to a case showing that very clearly and very recently. So that was Brack and Brack. Basically, even when there's no nuptial agreement, where you have a party having not enough to meet their own needs, the court will still say, well, you have needs. That doesn't change. Needs aren't conservatively assessed, basically, where there's agreement in place. It's still the same assessment. So that's a helpful quote, a reminder in these cases, whether you're for the party seeking to go behind an agreement because it doesn't meet your needs, or for the party wishing to uphold the agreement in its full terms, and you're challenging the needs being asserted by the other party who is seeking to go behind the agreement.